So with that, why don't we start with just a general overview of what the Board of Directors' duties are here. We're going to talk about Pennsylvania law specifically. So just from an overarching standpoint.
So we're going to look today, focusing, hopefully going quickly through part one, which is looking at the core legal concepts so that we leave plenty of time to get into some hypotheticals and some discussion at the end. And as Jacqueline said, we'll focus on Pennsylvania law here about these core legal pieces for nonprofit boards. So the first thing is that Pennsylvania has the business corporation law. This is what lays out the legal requirements for forming a corporation, which is something that I needed to go to law school to learn, that a nonprofit is a corporation. So let's start even there. So some of the key pieces of the VCL are that sets out that you're going to need a registered agent and your address. You need to set out your purpose. You need to file articles of incorporation. I'm assuming all of you are here because you already have an existing nonprofit, so we're not going to spend too much time on all the things you need to do to get one. And then here we are at the most important one, which is have a board of directors, officers, and managing the voting process, all of that sort of thing is also contained in the business corporation law. If you fail to comply with the statutes, an individual board member or a full board, there is legal liability for to a certain extent. Let's get into.
Sometimes I think people don't understand that.
Yeah.
Very basic and important concept.
That's right. Yep, exactly. And that's part of what we'll get into, of course, but that's an important piece of your duty as a board member is to ensure that you are safeguarding the organization's and your own fiduciary responsibility here by asking good questions, being fully informed, and making sure that you're making sound decisions as a board.
And I think what's also important for everybody to understand is that if you're a volunteer director on a nonprofit board, the statutes in Pennsylvania do offer you some liability protection just as a baseline. So long as you are not compensated and you are a volunteer, your personal assets should not be subject to the creditors of the organization so long as you do not violate your fiduciary duties or in some way be found to act with self-dealing or in bad faith. So there are some instances where you as a director, your home could be taken. Now, nobody in this room is going to act like that, I know that. So just be cognizant then of all of the factors and then protecting the organization, right? So that's really what we're going to focus on today is how do you protect the organization, because to get at your personal assets, you truly have to be a bad actor. So we're really not going to focus on that. We're going to focus on how do you as a director protect the organization by fulfilling your fiduciary duties. The first item here, what you see in the middle is actually the duty of care. So there's three duties. There's the duty of care, the duty of loyalty, and the duty of obedience. And this is the duty of care here. And above that, there's a reference to the business judgment rule. So as we all know, hindsight is 20/20. So let's say that you think that you are making the absolute best decision on behalf of the organization. And then 3 years later, it turns out to have been the wrong decision. The business judgment rule is what comes to save you because, again, we cannot operate on a hindsight's 20/20 basis for determining whether or not you were a good director. So long as at the time you made the right decision based on all the relevant facts and circumstances, you will be protected under the business judgment rule and you will be deemed to have fulfilled your fiduciary duties to the organization. The first of which, as I said, is here, the duty of care. So the duty of care is to act in good faith in the best interests of the organization and with reasonable inquiry, skill, and diligence that an ordinarily prudent person would use in similar circumstances. So that's a mouthful, obviously. So what does that mean? So basically it means that you have to look into the necessary facts to make a decision. You cannot just sit back and say, sounds great, let's do it. You need to take action to say, what do I need to know to make sure that this is the right move for the organization? And in doing so, you can rely on accountants, you can rely on counsel, you can rely on committees whose job it is to do that particular delegated activity. So it's not just you necessarily being the fact finder here. You can rely on certain individuals to counsel you to ensure that you're fulfilling your fiduciary duty of care. So I guess I jumped ahead a little bit. So a little bit more on the duty of care. You can see here a lot of what I said, so I'm not lying, is on this page. So again, informed judgments, making sure you have the facts, clarity on the issues, ask questions. The worst thing you can do as a board member is be afraid to ask questions because you think you're gonna make the meeting go longer. That is your purpose as a board member, is to ask questions. You are not there to rubber stamp whatever somebody is saying to you, okay?
Duty of care obviously is critical, but of course there's also a duty of loyalty and the duty of obedience. They may not be what they sound like. Starting with the duty of obedience, that's not, as Jacqueline said, to blindly rubber stamp what some report is at your next board meeting, but in fact to ensure that the board is compliant with federal, state, and local regulations, and that you're operating in a way that is in line with the organization's mission and vision. Loyalty, the duty of loyalty is essentially gets to the piece that Jacqueline mentioned earlier also, which is not to engage in any self-dealing, to make sure that board members, even though they can engage in financial transactions with the organization, but to ensure that any potential issue there is disclosed, make sure that they're updated conflict disclosures that you fill out annually as part of your board service, and that you are putting aside any of your personal and professional interests when you are serving as a board member and putting the nonprofit's values and focus ahead of your own.
The duty of obedience, just real quick, one of the interesting differences between a for-profit and a nonprofit in Pennsylvania is that for-profits don't have this duty of obedience. That doesn't exist at the for-profit level if you are a director. It is unique to nonprofits, and what it really gets at the heart of is the mission and ensuring that you are operating in compliance with the organization's purpose. Again, very distinct to the nonprofit world. For instance, if your purpose is to feed the homeless in Philadelphia, you can't be operating an animal shelter, right? So those are the things that seem pretty, okay, yeah, of course, duh. But you'd be surprised how many people allow mission creep to happen in ways that totally change the organization that maybe is not in the best interest of your constituents in terms of the charitable class that you are meant to serve. So just a unique aspect of nonprofits. So how do we protect ourselves as volunteer board members? Like I said, there are statutory protections for volunteer board members, so long as you don't engage in self-dealing or willful misconduct, again, bad actors. But otherwise, in order to further protect you as a volunteer director and in order to protect the organization, you always want to make sure that your organization has what's called directors and officers liability insurance. This is distinct from general liability insurance, okay? It is a totally different concept. It protects your directors and your officers and the decisions they make on behalf of the organization. It also, for federal tax purposes, can help us protect against any excise taxes that might be assessed against the IRS for excess benefit transactions or any other federal tax failures for which excise taxes might be involved.
I have a question.
Yeah, Donna.
Getting back to the duty of obedience with faithful to the organization's vision and mission. I have seen on occasion like one organization wants to support another one through some type of sponsorship or attending their event. It's not necessarily running the animal shelter, but let's do a sponsorship for them. And I think it's kind of like you scratch my back, I'll scratch your back, because they realize that there's some good fundraising opportunities with that organization. What are the pitfalls there? I mean, what's the worst that? What are the horror stories with something like that? Because that's probably an area I've seen more than just running the animal shelter. But let's we've got somebody on the board or a former employee, or there's a relationship there.
Yeah, absolutely.
How is there a line that you can draw that say, you can't run the animal shelter, but you can help with one of their fundraising activities by doing a sponsorship? Is that a problem?
No, I don't think that that's a problem,
Okay,
so long
okay.
as you have unrestricted funds that you can use for
That
that.
you can use for that,
So you shouldn't
okay,
be
alright.
using any restricted funds, cause those have to be used for the purposes for which they were given.
Yeah,
So if you have
okay.
unrestricted funds and there's a business reason behind doing that, like the I scratch your back, you scratch mine, I think that's absolutely fine. You just need to keep in check the levels at which you are providing assistance to other
Okay.
organizations so that you're not doing it to the detriment of your own mission.
Yeah, okay, alright.
And the other thing I'd add, Jackie, is I think the business purpose to doing that is that you are putting your organization's name out there through that sponsorship, right?
Yeah.
You might have an ad in the book, or you might be on the website, and you'll probably attend the event and network with potential donors.
That's, yeah,
That's what I
great
see
point.
as the
Okay.
valid business reason for
Mhm.
that. But as
Okay.
Jackie said, not at the big levels, more at a modest
Yeah.
level, right?
Okay,
Yep, great.
thank you.
Do you have, going back to the D&O for a second, do you have thoughts on how organizations should evaluate how much D&O to have? And maybe a second question, like have you seen situations where organizations have actually blown through that coverage? And then what happens?
Yeah, so one of the interesting aspects of D&O, not necessarily in terms of blowing through, but in terms of inapplicability, comes when there's an internal dispute between directors. And so we see that a lot. So the one thing to keep in mind that comes up most frequently with D&O coverage is the fact that it will not apply if you have an internal dispute. And we see that all the time.
Sorry,
Because
can you give an example of what you
yeah,
mean?
so let's say you have an issue between two fractions of the board and nobody can agree. And one side wants to remove some people and the other side wants to remove other people so that they can control the board. Or somebody's accusing one side of the failure of a fiduciary duty. And the other side saying, no, if anything, you guys did that. Those are the fractions that we see that are created in boards, and in those cases where a fraction of the directors want to sue the rest of the board, that's where that coverage is not going to come into play. In terms of the appropriate levels of D&O coverage is pretty inexpensive in terms of, liability coverage in general. The biggest issue is that you make sure you have it. Hopefully you'll never need it, obviously, like all insurances, but you have it and that it covers, I would say, at least 75% of the assets that the organization holds.